Welcome to Voices Beyond the Spectrum. Real stories, brave voices, radiant perspectives. This is the podcast for parents and caregivers of autistic and neurodivergent children and teens. I'm your host, and each week we hold space for honest conversations, shared struggles, and hard-won victories from those who truly live it. You're not alone. Your story matters, and it starts here. Hi, everyone. Welcome back to Voices Beyond the Spectrum Resource Hub Edition. I'm your host, Karla Chinen, and today we're having a really important conversation, one that so many families find themselves in but don't always feel prepared for. We're talking about what happens when there's a disagreement between families and schools, and what options families have when they feel like their child needs are not being met. If you've ever sat in an IEP meeting and walked away feeling unheard, confused, or unsure of what's the next step, this conversation's for you. I'm really honored to be joined today by Devon Rios. Devon is a special education and civil rights attorney here in Southern California, a strong advocate for children and families navigating these systems. She also serves as founding board chair for Via Care Community Health Clinic in East Los Angeles, helping ensure families access care for families regardless of insurance status. She has also lectured at universities on special education, juvenile justice, and equity. But beyond her professional work, Devon is also a mother of a neurodivergent adult, which brings a whole different level of understanding to this work. Devon, I would love for you to start here. Can you share a little bit about your journey, both as a mom and as an attorney, and what led you into this field?
Absolutely. Thanks for having me, Karla. It's so great to be here and talk about the process. This time of year, spring is like usually IEP season, and people are trying to prepare and things like that. So I'm so happy to be here. What led me here? So when I was a first year law student, my son was 5. He is well into his 20s now. He's an adult. But during that time, I was navigating the IEP process. And I could not believe that as a law student, I was struggling to get his needs met. And I'll never forget the moment an administrator lied to me. I was sitting there and it was kinder. Little guy had so many fine motor and sensory needs. And what the administrator told me straight to my face was, we do not provide occupational therapy at school. It's medically provided. So we suggest that you go speak to your doctor. And so that was sort of the starting point for me, where I basically told myself, well, you're in law school anyway. Why not make this the career? Because you're spending hours on end researching in these meetings, being told no. And I will say, like, as a parent, navigating the IEP process is completely different than just sending your kid to school. In terms of mindset, you never send your kid to school going, I'm going to disagree with the teacher. I have a right to disagree. I'm concerned about progress. And so I have to trigger this legal process. If someone you walk into school trusting teachers, deferring to their expertise, deferring to the process. And so it takes a lot, right, to get to the point where you're ready to assert your rights in disagreement. And so that led on an interesting journey. We actually initiated due process 2 times. There was disagreements about reading services and supports. And that was a really difficult window, but it was a window. And so chances are between 3 years old and 22, if you are in the education system that long, you're going to encounter a disagreement. It's not an if, it's a when.
Exactly. Exactly. And, I always like to start by grounding us like in the reality of what our families are experiencing. And because this usually doesn't start with legal terms, it starts with the feelings, something that doesn't feel right, maybe services that aren't being provided, maybe your child needs aren't fully understood, like you mentioned, or you feel unheard or dismissed in meetings. And that's, I think, when families start looking for answers, correct? So based on your perspective, what are you typically seeing with the families when they reach this point?
Absolutely. So when families finally reach me, it is usually after a long time of trying to have your needs heard. A lot of times there'll be an incident. This is pretty typical. It will be one incident that will push someone over the edge to where they realize they have to do something different in the process. Once in a while, a unicorn family will come in that they've lined everything up. They have their experts. They have articulated their request in the IEP and they know exactly what they want. And what I hope to share with folks is how to get to that point to reduce the stress level when you do have a disagreement, because you're the only person in these IEP meetings that has that emotional attachment, right? And being able to navigate the process in a way that will lead to the outcome you're seeking is what helps manage those emotions. And so it's twofold. It's one, being prepared to win if you have a disagreement, or at least do your best to present a case. You want to present yourself to an attorney in a way that makes it feel easy to work with, and understanding the emotional part of this before you walk in.
That's very, very true. And I think the hardest part as a parent, to be able to have that control over all those emotions, because I mean, you're talking about their kids, and a lot of the times, a lot of parents feel that they go into these meetings not knowing terminology, not knowing the jargon, and then on top of that, being dismissed as just a parent, where obviously that's with the organization that I run, where we try to focus on providing that additional education for the parent, and allowing them to understand that they are a very important person in that IEP or in that process, because they know the child best during that process. So it's wonderful to hear that from you, and to get that perspective as well. So I want to start also with something that families hear often, but not always understand, which is ADR. So, Devon, can you please explain what ADR is in a way that families can really understand?
Absolutely. So ADR stands for Alternative Dispute Resolution. 90% of districts will have an internal dispute resolution process to address parent disagreements with an IEP. And we're going to talk about the different levels of dispute resolution. So it can go from a simple discussion at the IEP table, right? You make a request, it's discussed, and ultimately there's agreement, right? Where, as an example, a speech pathologist might say, we would like to offer 20 minutes per week of individual speech. And you might say, actually, based on articulation needs, social skills, and expressive language, I really think that my child needs 45 minutes a week. And that might be a situation where you disagree, but it's resolved in the meeting. The speech pathologist might say, okay, that's agreeable, let's try it. And then what you request gets in the IEP, done. Next level is an ADR, and districts call it different things: alternative dispute resolution, informal dispute resolution. So it might be IDR. What you're looking for is information about the local dispute resolution process in your district. So that's the first option in terms of getting your concerns and disagreements addressed.
Perfect. Perfect. And then, so let's say a parent wants to start that process. Is it something that needs to get implemented right away, or is it brought up during IEP, or is it something the district brings up? Because I know these are typical questions that parents ask.
So once you make a request, so that is like nugget number one. You have to clearly state what you are requesting in the IEP, and there has to be a clear yes or a no. And in that process, and this is important because once you initiate this process, you're the one that needs to prove the need. And so I always tell parents, there is a huge difference between knowing something is wrong and knowing what you think is required to address it. And so most successful dispute resolutions, the parent knows what they want to address the concern and the disagreement. So as step one, that's done. You've made the request in the meeting, you've talked about the needs and made the request, and it's denied. And then what you're supposed to get is what's called prior written notice that documents in a letter very formally what they denied, what they offered instead, what they considered in that process, and then discussion about your procedural safeguards and rights moving forward. And so that should happen. And then the next stage is deciding whether you want to initiate this dispute resolution process or not. So it happens after the IEP, typically after you've given a response, and you're in a new stage of trying to figure out how to address the disagreement.
Perfect. And how should families prepare before going into that process?
So This is the prep. I want you to think about an IEP like a house. And so you're building a house, right? And the first thing you're focusing on is foundation. And so your foundation is assessments. And so I want you to think about, like, if you're building a 5-bedroom house, your foundation's not going to be teeny tiny. It's going to be what is required to support a house of that size. And so the first piece is always having current assessments, current data. And 9 times out of 10, if you are concerned, you really might have to think about independent education evaluations, IEEs. And we can talk about that as a whole separate piece, but that is your foundation. It's not pretty. It's not fun. It's not the part where you're going, I think my child needs 45 minutes of speech. This is the part where you're going, we have expressive language needs. We have all of these different details of need. And if you don't slow down there, your house isn't going to hold up. So you want a solid foundation, no cracks. Then what you build is your walls, right? So your goals. And your goals need to be, and you have to have enough. So you're not going to want to have, if you know you need 4 walls, right? Yeah. Two walls is not going to be enough. So you need to, and you might have a disagreement at any place in this process, right? So your disagreement might be at foundation with assessments. And then the next step, you might need dispute resolution for that. Your disagreement might be with goals. The goals are not adequate. Hey, a house needs 4 walls. I only have 3. Or these walls are flimsy. They're never going to hold up a roof, right? You have to have all the goals. So once that's done, and you might have disagreement there, and then that's where you initiate process. Then you're talking about the roof, right? And all of this is not the stuff you focus on in a meeting, because everybody wants to get to it. When you're building a house, you want to decorate, right? You want the finishing touches, the kitchen, the whole thing. We're at the ugly building pieces still. So your roof is the placement, the services, and that's last. You would never build a roof first, right? You would never go build me a roof, no foundation, no walls. Let's just suspend this roof in the air. But parents always walk into IEPs, and I get it, because you already know end game, right? You want the service, you want the aid, you want the support, you want this thing addressed. You got to go foundation, goals, roof. And then we're talking about color. We're talking about what the kitchen might look like. But all of these foundational things have to be done. You might have a disagreement in any place, and each of these has to be thought out separately. So you might have a dispute at any piece. Parents that understand that are so much more prepared to be able to efficiently resolve the dispute. And then notice in that process, right? I'm not a contractor. I'm not a builder. I know what I want. I can hold vision. I know my house needs to be 5 bedrooms. I know that we have to have an open floor plan, right? But I don't know how to build that. I'm relying on experts. And so that's the other piece, is building your team and having your experts in place to support what your vision is. So having that is critical.
Definitely. And you did mention experts. So we're going to back out a little bit into the IEE, independent educational evaluations, and what that consists of and where those come in. Excuse me.
Absolutely. If you end up, because we're just at ADR, right?
Yes.
And so just to put a bow on ADR, ADR is typically the best option when your dispute is simple, straightforward, and you know exactly what you're willing to accept and what you won't accept, and you have to be willing to walk away. And so usually ADR is difficult when there is a lot of disagreement or very, very different perspectives. And so ADR might be good for I keep going back to speech because I think it's the easiest example, but let me know if we should use something different.
Oh, no, that's I think a very common need.
Yeah.
In our community.
So speech path says 30 minutes of speech. You want 45. That is something where ADR might really be your best option. Typically, ADRs are for the simple stuff. Now, this is not to say that you cannot resolve a complex issue in ADR, but you still have to be very prepared. And you also have to have your evidence, which comes in the form of typically independent education evaluations. So due process, when you're in due process, the parent has the burden of proof. So it is not the school district, if you're ultimately in front of a judge, it is not the school district's responsibility or requirement to prove that the IEP is appropriate. It is your job to prove that. And how can you do that without experts? It's impossible. So what I tell parents is the independent education evaluations are the tools I need to do my job. I can effectively represent you. I can do that work, but I need my tools. And that's the independent education evaluation. If this is a good spot to sort of get into the nuances of an IEE, we can. Or if you want to save it for later, we could do that too.
We can start diving into that. Yes.
Okay, because it's so important. And so the earlier on you understand this, the better.
Yes.
So districts have built-in experts that spend 6 hours a day, 8 hours a day with your child, right? And these are folks that chances are have credentials, have experience, and they're seeing all the nuances. And not only are they seeing the nuances, they know your kid. And, once in a while you have a professional that might be phoning it in and not know your child at all. But chances are they've gotten the gossip, right? They get the little kid slips about stuff, or, they kind of know when a kid might not be sent with their device. They get all of that perspective because they spend day in and day out with the child. And so they are, even if they are not incredibly prepared, they typically are able to present a rationale about your child and why they offered what they offered. So a lot of times families will ask me, I got a medical evaluation and the insurance paid for it. Is that enough for an independent education evaluation? And unfortunately, it is not, because these experts have to observe at school. And this is not a little pop-in 20-minute cute classroom observation. This is enough time to support whatever opinion they arrive at. So that might mean they're seeing structured time, unstructured time, multiple days maybe, service provision. They need to have that information to connect the needs that their assessment finds to performance at school. So if that is missing or even deficient, it's a weakness. The other piece is they have to interview and get the input of the providers. So this means the rating scales from providers, talking to the teachers, maybe talking to outside providers, and all of this, and parent and child. So all of this has to come into play. Ultimately, it's because you have to support whatever you're asking for in court. It's your burden of proof. And so that absolutely has to happen. And then we're kind of living and dying by the recommendations. And sometimes a situation is so difficult and things are so bad that you can reach a resolution without that. That is the exception, not the rule. And the way that you get to a good resolution is by being prepared to litigate if necessary. And that's what you need to be prepared.
I've gone through due process with my son, and I have a friend, and she was so concerned because she was starting that process as well. And she's like, what should I expect? And I'm like, well, even before you enter that process, you expect like at least 5 to 10 IEPs for the year, because it's going to be meeting. And then you also have to prep, like you mentioned, all the professionals, request IEEs, independent education evaluations, because you need that proof in order for any lawyer you hire, for them to have sufficient data to back up whatever services you need for your child. It's going to be very stressful. It's going to be a lot of back and forth. It's going to be a lot of the times them pushing buttons where you're going to have to say, I need a break, because you don't want to come off as unprofessional or say something that's going to backfire on you because you let your emotions get the best of you. And it's easy, for that to happen when they're talking about your child. So just keep that in mind, and make sure that you have that open communication with whoever you hire to be able to understand your needs and be able to implement or get sufficient data for them to be able to do their job adequately.
So every time the district does their own assessments, parents have the right to request an IEE, but it's not guaranteed that it's granted, because the legal standard was the assessment legally adequate? It's not that you loved it. It's not that You agreed with the recommendations. It's not because you have to go to due process and you need someone to pay for these experts. Did they check all the boxes of a legally adequate assessment?
Mhm.
And sometimes school districts choose to file their own due process complaint instead of funding the independent assessment. And so they might stop the whole trade at the foundation of the house, right? So I just want to be clear that even requesting the IEEs has to be well thought out, and you probably need some legal basis. You're not required to share why you're asking for an IEE with the school district, but you have to know what you're walking into in terms of breaking, like you have to know the deficiencies and the likelihood that it's going to be granted. That is critical because you could be on this due process track real quick if you don't know that. And a lot of times it's extremely unfair because parents with resources can pay for their experts, and districts still has to give you the opportunity to observe, the opportunity to interview the teachers and present at the IEP, even if it's self-funded. And I'll share this as going back to the parent perspective and my experience. I spoke with an attorney for my son at some point, and what she told me was hire the expert, pay for the expert. Don't mess around with this request process, get your expert. I was a first-year law student. I had no money. I was young, I had no money. And I laugh now because I feel like I still have that credit card lingering around somewhere that I put that expert on. Like I was rolling that thing over for years. It was like a $6,000 investment.
Mhm.
And I did it. And that was probably the best decision I ever made. I couldn't afford it. Absolutely could not afford it. Had no business doing that, but I did it.
Yeah.
And I owned that information. That was my person. And I worked with for him until he graduated from high school. And so that's the importance of it. One, it helps you, but it also gives you that peace of mind that you have feedback from someone that's outside of this process that knows your child and can tell you kind of where things should be going.
And thank you for sharing that because, yeah, sometimes some parents are not aware that the district can initiate the due process. And if they're not financially prepared to go on, and hire a lawyer and do all that process, they might put themselves in a situation where now they don't know where to turn or what to do. So thank you very much for opening up also that perspective and how it could spiral down really quickly if a parent is
Yeah,
not prepared to or understands what the consequences are of certain requests being initiated.
exactly. I want you walking in eyes wide open.
Exactly. That's why these platforms are so important for families to learn this, because a lot of the times our parents are stuck in meetings or in therapies with their kids that they can't sign up for at the next IEP meeting or IEP trainings. So this really provides an additional opportunity for them to just plug in and learn this from you directly. Who better than an expert? Devin, thank you.
Yes. So next step on the ladder, there is a mediation only option. And so this is like due process light, if you will. So what you can do is fill out a request form detailing some facts and your concerns and your proposed remedies. And you file with the same court. It's the California Office of Administrative Hearings. And you say you want a mediation only. So what happens is the state will send a mediator to try and resolve the dispute between you and the district. But if that is not successful, there is no subsequent due process hearing where a judge decides what happens. This is like the medium option, right? If ADR is light, this is medium, where and they're competent mediators, right? They come in, they hear both sides, they try and bridge the gap. It's virtual. But if you don't resolve, you don't resolve. And so it's an option. Similar cost benefits to considering mediation only as a way to resolve the dispute. And then the next step is due process. And the other piece I will tell you is consult with attorney through this whole thing. There are lots of special education attorneys in California and Southern California. The Office of Administrative Hearings has a list of attorneys that will do free or low cost consultations and due process representation. So as another tip, if you have talked to several attorneys and none of them are willing to assist, that's a red flag for you that you're missing a piece in the process, or you want to address a dispute that's not resolvable in due process. This is like an emotional piece. I'll take on a little side quest for a second.
No, go ahead, go ahead. I love them.
Because there are issues and disputes that are resolvable in due process, and there are things that are not. And so you can resolve concerns with assessments, services, placement, and your remedies are usually change of placement, compensatory education, assessments, right? Due process is not going to fix personality disputes. And this is very important because as adults, we all don't get along, not all the time. And you're going to get some lemon teachers in this process. Chances are, most folks, you get some really wonderful teachers and you can get some really horrible ones, right? This is the luck of the draw. Providers, teachers, administrators, people are people, right? So we can get this beautiful settlement done. You can get a wonderful order from the Office of Administrative Hearings that will not make a person enjoy their job or do things with love and joy and care. And so you have to step back and go, is this a personality dispute? Is this a personal thing? Or is this something where I can live with a vanilla kind of remedy? Because there's nothing that is going to fix those personality disputes unless we're changing. Fresh start, right? We are changing people. So keep that in mind. And that's another piece about the emotional check. So the next step is the due process piece, right? So it's a formal process. It's supposed to be parent friendly. I have never seen a school district go to due process without an attorney.
Yeah.
I've never seen an OAH decision, and you can search them. You go on the OAH website and they have a decision database. You can pull those decisions up. I have never seen an unrepresented school district in a due process decision. So I'm applying some common sense here, right? If they have an attorney, you probably should. Now, having said that, I've seen self-represented parents get results. It's not required, but I will say chances are it is very rare to see a parent do that and not at least have some back end help. So somebody's talking to them, be it a very skilled advocate, be it an attorney on the backside. Yeah. Somebody's helping with this process. If not, I'd love to email me. I'd love to meet the person that did that winged it on their own, got this great result, and that was it, right? But so you really should have an attorney. Also, you do not want to be the person. These cases are hard. Even with an attorney, if you end up in hearing, everybody walks away unhappy in some way. So it's a very challenging standard. Very rarely do people prevail on all issues. So I say this because you don't want to be the person that produces a decision that then impacts others. I had a recent local situation, and I won't name names, but some administrators get on a high horse and are aggressive and want to make a point, and they don't care what family they're going to make the point with. They want to go to hearing to make their point. And so if you do that and you're the person that makes the point, guess what happens? They're emboldened in their decision making, and then the process just continues unchecked. This is a very long-winded way of saying find an attorney. And there are so many attorneys in this area that will do it without a retainer up front. The way it works is if you have the law says if you have to attorney to have your child educated and go through this process. If you win, the district has to pay the fees. And so you need to just keep trying to find an attorney, which is kind of the second point of you got to start this process early. Like if you think that there's going to be a disagreement in June, you're lining this stuff up September, the year before. And so due process is it's formal where you'll file a formal complaint with the Office of Administrative Hearings. You have the option to have a mediation. Before that, you'll have a resolution meeting with the district. And then you go through a hearing. And the hearing is application of the law. It is not this like creative solution driven process. It is the law applied to your facts and a judge's discretion on what they order as a remedy. And it's difficult. It can be weeks long where you have to be there every day and you're calling witnesses. You're presenting evidence, the judge is asking questions, your attorney's asking questions, they're asking questions. You have to be really ready to die on the hill over what you're asking for.
It was a very draining process, not only for myself as Adrian's main caregiver, but just everything of the uncertainty. And sometimes when you're going through the due process, sometimes the children are home with you, not necessarily in school. So it's adding that additional stress here at the home, not knowing when it's going to end or how many more meetings you're going to have to meet before it finally comes into a resolution or you go to the full process. With that being said, what are common mistakes families make during this process that can really hurt their case without them realizing it?
Okay. And I'm going to spit this out without like, this is not in order of importance, right? But common mistakes. One is to what you just said, engaging in this process when you are not emotionally ready for it. I would venture to say that if you are in a very contentious situation with the district, this is probably just as difficult as a death. Litigation is litigation. It is not for the weak. And this is not to discourage people, but chances are, if this was a phone it in easy process, you should have done an ADR. If this was as easy as picking up a phone and saying, hey, can we fix this? I wouldn't have a job. I would gladly go open a bakery or something, but I have a job because this is not easy. So it has to be the right time emotionally, physically, and the way you can control it is understanding what you want. And is it supported legally? Is it supported by evidence? Mm-hmm. And that is where it can turn into, if the remedy is unclear, the situation is very, very stressful, it can become very clouded, very anxiety provoking very fast. Sometimes you don't have control over that. And as special needs families, I'm sorry, but you're probably used to having to fight these fights when you're not ready for it and you're drained already. And so sometimes you don't have a choice, but if you are lining this up strategically, because you know this is coming, it helps manage the difficulty of it. And it's so personal. There are very few things that are more personal than going through an IEP for a parent. You are the only person that's sitting at that table, and we are talking about your baby's challenges. It's need driven. It is not driven. We're not talking about and we should do more of it, but we're not talking about the good. When we're sitting there, we're talking about meeting needs that often are framed as deficits. Really, it's a difference, and these things should be embedded, and this process shouldn't be so difficult. But as it stands, it's framed as strengths and needs. And these things that are different from their peers that are required so that they can be educated with their peers. And so it doesn't feel good to sit there. It almost feels like grief a lot of times to sit there and have these conversations that are framed in a way that has to highlight the need to get the support that's required. I hope as a society we evolve into a different system, but that's where we're at right now. And that's how it feels. And I like being honest about that, because I don't want to sit here and tell people, oh, it's not a need-driven process. It's not framed in terms of difference. It is. And that's why it feels this way.
And no, and it's very, very true. Like, I think the communication and how, I guess, professionals could use more strength-based language with our children. And when they write these reports, and, that's another big portion of us as an organization trying to spread that awareness within our own professionals and our teams. But with that being said, when a way I word it for my families when we do these IEP trainings is embrace the deficits, and out of that, use it as a tool to get your child to get more services based on those deficits. You have to word it and change your perspective on. It's hard as a mother to kind of digest those. And if later you want to grieve it outside the IEP meeting, you do that for yourself. But with that being said, use it as a tool for yourself to be able to get your child more things. So if they tell you your child can only say 2-3 words, then let's increase the minutes that he has with that speech pathologist so we can get to that higher goal faster, So just reframing it. Also, when you have parents that are barely starting the process of them getting the diagnosis of the child, that are still going through that denial process, letting them know, using that diagnosis as a tool once again to be able to access services for their child. It's not going to change who their child is. It's not going to provide them another layer of identity. It's just part of using it as a tool in the system that you mentioned. It needs reform, but it still is what it is. A breath of fresh air that you do bring that up as a professional.
Glad. It's uncomfortable. And I'm going to be honest, I question it a lot of the time. Right? As to, having the context and the history of IDEA, understanding that it's a statute that is not that old. It was 50 years old as of last year. And it's in essence an anti-segregation statute. So it's designed to make sure that children with disabilities that learn differently are included with their typical peers to the maximum extent possible. And so the whole framework is built around this system that acknowledges it's not designed for kids that have these differences. And so the whole thing can feel very icky. And so, but I don't, on the flip, it's also parent driven. So if you chill and you don't engage, the school's not going to engage. And I'm open about this with my oldest. I don't know how happy he would be with me talking about it. He needed and he needed a lot of help learning how to read. And that was my issue that I died on the hill for. He was going to meet survival level reading, and I had the assessments and the support to demonstrate that that was a viable thing. Was it absolutely unfair? Did having to go through this labeling process, this BS, this like specialized stuff have an impact on how he viewed himself? At some points, yes. But I step back and go, but dude, you know how to read. So just engaging in that, I just don't want to dismiss the way it feels. And you're feeling it because it's personal. It's not really personal to anybody. You could be surrounded by lovely providers that are engaged in their job and care. You're still not this child's parent. So I think, going back to the like common sort of issues are like not being prepared for that could impact your ability to engage in the process meaningfully. And so to the extent you can be financially ready for this, emotionally sort of prepared, and no attorney can't tell you what the remedy is. We might know professionals in the field, we might have ideas as to where you could seek things, but I'm not a psychologist, right? I'm not a behaviorist. I can rely on those experts for their opinions. But if you walk in and you don't know what you want or what you need for your child, I can't tell you. And so that's another common challenge for folks, is that they think the attorney's going to tell them what to ask for. We can tell you the likelihood of receiving it, the providers that would be available, your likelihood to prevail. We're looking at this from the perspective of, is this offered settlement agreement that this family's getting? Are they going to do better at trial? We're weighing that, not going, oh, I identified your need for speech, and I think you should be asking for this. So that is, walk in the door or walk in knowing that you're seeking their advice on who to speak with to get that information. Lots of attorneys, and me especially, I love it. I love helping people prep. It's not necessarily recoverable under special education. A lot of times I have to charge. A lot of times, if you're nice to attorneys, here's another little tip, and we have some time, we're going to give you little nuggets to help. Like, we're not in this profession. I'm not hungry. I'm not like doing badly, but this is not the $1 billion kind of field. Most attorneys are in this field because they want to help. So if you work that relationship, as you can see, like if you get me talking, and so, so engaging with an attorney early or a very skilled advocate, that's a whole other topic, but there are skilled advocates out there that can help with it. That is another piece that's important to just have that lined up. I can't stress the importance of the independent experts enough. You need it. If you end up in hearing, there's no way around it. And so knowing that up front is important. The other thing we didn't touch on is understanding the legal standard, which is free, appropriate public education. This could be a whole topic in and of itself, but the focus in due process is usually the appropriateness. And what appropriateness means is driven by case law, is driven by this whole sort of analysis as to what is appropriate for your child. Understanding that appropriateness doesn't necessarily mean the best. It doesn't mean the worst. It is not this kind of fixed black and white thing. So understanding that when we're talking about appropriateness, it's very different than talking about what's best, what you might really want for your child. It's not what we're talking about. I never tell parents to not want the best for their child, because it's ridiculous. Like, every parent wants what's best. Even parents that can't provide it are struggling as parents are not going to sit there and say, I don't want the best for my kid. That's a pretty small population of families, right? So yes, you want the best. You're going to advocate for that, but the legal standard is not the best. The legal standard is appropriate. And so knowing how to that's why you need the guidance of an attorney.
Thank you. And for our families that are going through the process right now, what would be some encouragement you can give them to close this off and to, provide them a little bit of a hope and guidance in that regard?
But yeah, all right. So I sat here for an hour and talked you out of this really hard process, right? if if you have to go through this, know that this is not going to be the rest of your life. If you're in due process every single year of your child's education, there's something else going on. The remedy's not being addressed. And that's twofold, because on one hand, you can have a dispute 1 year and then you have to have another IEP like right after, right? But chances are these very true disputes that are so important that you need to engage in dispute resolution. Hopefully, this is not happening for your child's entire career, maybe 2 or 3 times. So keeping in mind that this is not forever. Litigation does end. These processes might take some time, but you're not going to live in it forever. And so sometimes you have to do it and it's worth it. It's the time of year, and I've been doing this long enough where I'm getting the graduation announcements, the like thank yous. And these are for little ones that, well, they're not little anymore, but like when I was working with them and we were establishing these foundations, they were elementary, middle school, and now they're getting ready for the next step. And so it does end. And so you're not going to be doing this forever. It's worth it if you're lined up and you know this is a hill you got to die on. And hopefully you don't have to do this all the time. It's not going to be forever. So it's worth it from that regard. And sometimes you don't win, but knowing that you can go to bed knowing that you did everything humanly possible to do right by your child is worth it.
Amen to that. Is there any, I know we can't say too many names, but is there any story you would want to share that really stuck to you in your journey so far and that you're like, oh my goodness, this is why I wake up every morning to go and do this because of results like this?
Another tip, special education attorneys actually really love updates.
Hey.
And I mean that because it's challenging work. This might be one moment in your life, right? That's very, very hard. This is what we do day in and day out. And so a lot of times, I'm gonna vent a little bit. We get to work on the problem and then we never hear about the solution, or we never hear about the progress, right? Like it's gone. And so in terms of even just knowing how things are going, like I love that. And so even if it's knowing what you learned in the process, they're not all winners. Like sometimes it doesn't work out the way it needed to work out. And sometimes the fight is just the fight. So from that regard, and I keep my caseload pretty small and I tend to do a lot of front end work with people. And part of the reason is I like knowing all these details. I don't like cranking it out and kind of moving on because I don't know how to do this any other way. That's what keeps me going, is going like, end of the day, that behavior support or that implementation of that AAC device unlock this child's ability to express their needs. Like those pieces, it's why I move kind of methodically and with a small caseload, because I don't know how else you can do this any other way. So I'm proud of all of it, and there are some cases that don't work out how you hope. But yeah, I would say that, those pieces, I'm always excited when like systems change, like when you hear that, a process is done differently now. Those always make me happy. To know that we improved a process or a program that we fought really hard for a kid is now being implemented, in classrooms. That's always cool. It's always cool to see like the dynamics at an environment change as a result of one person's advocacy.
And then I have to bring this up. During our December event, you were so kind to share with us some amazing certificates of something you launched. Do you want to share a little bit about that with our listeners so they know that they have that additional tool available?
Absolutely. So I developed an online sort of access at with like what you said, sitting in a doctor's appointment office, waiting, you can access at your leisure pre-recorded education around this process. And so I break down all pieces of it, from understanding assessments, developing the goals. They're anywhere between 8 to 15 minutes long per module. It's pretty affordable, and you have lifetime access to it. So a lot of times when people are not ready to work with an attorney, I encourage them to purchase the course. And that's the other piece, is like, this is not like a car accident, right? Where you have to hire an attorney for your injury that happened one time and it's over. You're going to have to know this process, at least in the big picture, for the duration that your child has an IEP. And so it's worth the investment to at least get the framework in a way that's digestible. And so however you get that, so that's Unspoken Rules. That's the course. I also offer smaller modules. If you want to just do I have an option on my website that is ask me a quick question. It's under $100. You can pick my brain. It says it's 15 minutes. I've probably stuck to my 15-minute rule. This is just like, my terrible boundaries in that way. Just you get to pick my brain, right? And I might even tell you, hey, like, the course is really for you. You need this foundational information. Everything I talked about ADR and due process is on my website on the frequently asked questions. Like, a lot of people don't look at it, but that thing is like the manifesto to the process. It's just like, it's FAQs. It wouldn't necessarily, but if you open them up, you're going to get the roadmap to everything. And so my goal is to be accessible, provide families with information so that they can avoid ugly litigation and get their kids' needs met. Or if we have to go, we're going. And that you're putting everything forward possible to resolve this dispute in favor of your child. So everything I do is designed around that. So if you poke around my website, if you poke around Unspoken Rules, you're going to find almost everything I just said.
Love it. Love it. Well, Devon, thank you so much for sharing your professional insights and your personal experience. I think that combination is very powerful for all our families to listen to. And for anyone tuning in, we'll include all these helpful resources in the links in the description area, so you can access Devon Rios' website as well as all the resources she provides to our families. It's not just about the process or the conflict that comes to it. It's also about making sure your child gets what they need to thrive. And with empathy, always here on Voices Beyond the Spectrum. Thank you, everyone. Thank you again, Devon, for being a guest and for sharing so much knowledge with our families.
Pleasure. Thanks for having me.
Thank you for joining us on this episode of Voices Beyond the Spectrum Resource Hub Edition. A heartfelt thank you to Devon Rios, Special Education and Civil Rights Attorney, for sharing her knowledge, her experience, and her continued advocacy for children and families navigating special education. If you found this conversation helpful, please take a moment to share it with family, caregivers, and professionals who may benefit from this information. You can listen to this episode on Apple Podcasts, Podbean, YouTube, and Spotify. This episode was brought to you by Empathy for Autism California, a nonprofit organization where we commit to supporting families, building community, and creating a more inclusive space for neurodivergent individuals across a lifespan. Music was brought to you by Brad Kalouv, with piano by Brad Kalouv and Sophia Chinen. Again, with empathy always, this is Voices Beyond the Spectrum.